Very honored to have as our speaker tonight Judge Arthur M. Schack. He's a major person in the court system here in New York City who understands well the law and also the human condition. He's a person of great intellect. He's an intellectual as well as a man in the judicial system. He's getting a wide reputation around the country for his fairness, in terms of wanting to see fairness in the court on all sides of people that are contained in a particular hearing or a particular situation. He's given particular attention, among other things, to matters of foreclosure and so forth within the mortgage situation that developed after and came to a culmination in 2008 that we're all familiar with, and the implications of that. He has great understanding and knowledge of that, and it's an honor. So please, let's give a warm welcome to Judge Schack. He'll talk and we'll get a question. Thank you. Welcome.
Thank you, Harold. And Harold, as I said to you a few weeks ago, flattery will get you everywhere.
And I'll use flattery again.
Thank you. Harold has asked me just to talk a little bit about what I do, and so maybe that's a good starting point before we have a give and take with questions. I am actually a justice is the title, not judge, but even though I get called judge, Justice of the New York State Supreme Court. Now, despite that lofty title, first off, I'm not on Mount Olympus, but secondly, the Supreme Court in New York State is not the highest court in the state. The Court of Appeals is the highest court of the state. The Supreme Court is the court of general jurisdiction with unlimited jurisdiction with respect to how much money can be awarded or how much money someone can seek. It's not a court of limited jurisdiction. Throughout the state, we try civil cases with unlimited jurisdiction in terms of the amounts that you can be awarded. All foreclosures come into the Supreme Court in New York State. Matrimonial cases, that's divorce, they come into the Supreme Court. And it's a whole gamut of cases: contract actions, personal injury, land disputes, and I can go on and on and on. Anything you could think of ends up in the Supreme Court. In New York State, there are somewhere in the range of 320 to 330 Supreme Court positions. They're allocated by the population under the state constitution. So if you go to a smaller county upstate, there might be one Supreme Court justice sitting in that particular county. I happen to sit in Brooklyn, which is Kings County. So we have approximately 1/6 of all the Supreme Court justices in the state, because we have approximately 1/6 of the population of the state. So that's how it works. In New York City, there's a little extra wrinkle. Outside New York City, we don't have this jurisdiction, but within New York City, we also try felony cases. If someone gets indicted for a serious crime for which you can go to jail for more than 1 year, that is tried in Supreme Court. So if you watch Law and Order, which many of you probably do, you can't avoid it with the reruns on all the time. That's actually in Supreme Court, where those cases are allegedly being tried. I'm not going to get into all the mistakes that they do in the criminal cases, but that's filmed around the courthouses. And so if you see Judge sits in part 32, the trial is in Supreme Court, New York County, usually in Law and Order. But right now, for the last almost 10 years, I've done very few criminal cases. I'm more involved with the civil side. Despite my reputation that Harold talked about, mentioning foreclosures, most of the work I do is not involved with foreclosures. Actually, I'm conducting civil trials usually 4 days a week. The 5th day, I'm dealing with motions with a whole gamut of cases. Probably more with personal injury than anything else, but that's the nature of the cases that come before me. I've written a number of opinions that are published. I think it's 238 right now, of which probably somewhere between 50 and 60 deal with foreclosures, because I had to educate myself in that area. But as I said, I deal with a variety of cases. I might also add, with respect to the Supreme Court of New York State, I am an elected judge. In the United States, we have a hodgepodge, what I'll call a hodgepodge way of electing judges, depending upon the state that you're in. Many states, judges are appointed. Depending upon the state, it could be the governor, it could be the legislature, some combination thereof, some other officials. There's some kind of process. There might be retention elections after people serve a particular number of years, but I can focus in on New York State. New York State has approximately 1,300 full-time elected judges. And I say full-time because we have about somewhere in the range of about 2,500 part-time judges who are primarily town and village justices. They don't have to be lawyers, and they serve in these courts of limited jurisdiction, whether it be minor criminal cases, depending on where they are in village or town courts, it could be up to $3,000. They're not major cases. But the judges who sit there full-time, who must be lawyers for at least 10 years before being elected or selected, sit in, they could be city courts, district courts, county courts, state Supreme Court, Court of Claims. New York has a number of courts, which is also an interesting system. Of our approximately 1,300 judges in the state, about 800 to 900 are elected. Again, Supreme Court judges are elected. We're elected for 14-year terms. In New York City, civil court judges are elected. I'll just pick on New York City for the moment. Family court judges in New York City are appointed by the mayor. Outside of New York City, they're elected, depending upon the county. There are some courts that only appear in New York City. That's Criminal Court of New York City and Civil Court of the City of New York, but those are state courts, even though the title is City of New York. Outside of New York City, we have some other courts that are only outside of New York City, whether they be city courts. City is a creature in which you have a mayor and elected council. There are 60-something cities in New York State that range from New York City being the largest to some that only have a few thousand people. And it has to do with the form of government. So each city courts have judges. New York City is a little different, as I said. So we have a whole range of things in New York State. But as I said, I am an elected judge. I was elected in 2003 for a 14-year term. And we have some strange math in New York State. I was elected to a 14-year term, but because of the way it works in the law, I can actually serve for 18 years. So we have the new math there, but I don't even want to get into that now. It's going to take me too long to explain it, what happens. I think there's more important issues. But I like the idea that I am an elected judge. It gives me the freedom to do what I think is right. And that's what I try to do, to try to be fair. Harold alluded to that, but my view is that there should be a level playing field for everybody who comes to court. So whether you're a large bank, or whether you're an individual, or whether you're a large corporation, again, you're a small business, whatever it is, the rules are the same for everybody. I don't think we should be Animal Farm and have some people more equal than others. We're all equal before the law. So my goal is to try cases as expeditiously as possible and to be fair. Of course, there are people can appeal my decisions if they don't like it, and that's why we have appellate courts. So. But that's also another story. But as I said, 4 days a week I'm doing trials. The fifth day I'm hearing motions because there are approximately 1,500 cases that I have that are somewhere in the pipeline that are assigned to me getting ready ultimately for trial, of which probably right now I'm only guessing because I don't have the exact statistics, maybe about 300 to 400 of these cases are actually foreclosure cases. So there could be another 1,100 cases that could be auto accidents, construction accidents, property disputes, contract disputes, a whole range of things that are slowly getting ready for trial, and I have to deal with motions as they get ready. New York State, we have what's called an individual assignment system, so I deal with, the idea is that a judge becomes familiar with the case as it gets ready for trial. And I have what I call my golden oldies because they keep coming back to me on motions, so I do get familiar with these cases. This can drag on. And then eventually, if I'm available or other colleagues of mine, on a rotation, we end up taking trials. I do mostly jury trials, and last year, the statistic we use is starting a trial. And I say starting because there could be a settlement, there could be something else could happen, there's some kind of disposition, or there could be a verdict, depends upon the case. So last year, because of some budgetary constraints we have in New York State, cutting the hours of the courts, I was unfortunately unable to start as many trials as I did in other years, and that's probably true for other judges. So I started 46 trials last year, of which I think two were non-jury, 44 with juries, and they were resolved. But some trials can go rather quickly, and others take a long time. Right now, I'm still involved in my first trial of the year. And at the rate it's going, this case, I don't want to get into it because it's a very serious injury. and the number of witnesses. This case could go another month. It's just very, very involved, and there's very good lawyers on both sides, and a lot is at stake. So it depends. Every case is unique, and I'm involved with that trial 4 days a week. So it's a variety of things. Now let me talk a little bit. I might switch gears now and talk a little bit about foreclosures, just to give you an overview of what happens. Every state is different with the laws that they have with respect to foreclosures. Formerly, I was just speaking to some folks who are here from the state of Virginia, which works a little bit differently than New York. I believe there are 23 states in the country that are what we call judicial foreclosure states. So 27 are non-judicial, and I don't know what the story is with the District of Columbia. I'm not sure whether it's judicial or non-judicial. But what it is that in New York State, let me back up. You need a judge to approve a foreclosure. When I say foreclosure, ultimately getting a judgment of foreclosure against somebody. And what happens in New York State, and I guess in most states is probably similar. Oh, no, I shouldn't say that. Well, let me talk about the procedure a little bit in New York. What happens is that in order to ultimately get a judgment of foreclosure, the plaintiff, which is the person, which is usually could be the bank, the financial institution that loaned the money, or whoever they assigned it to, has to do three things, which sounds relatively simple, but unfortunately it's not so simple. You have to prove, one, that there is a mortgage. There's a mortgage. That sounds relatively easy. With a note, actually a note and a mortgage. A note is really literally the debt. Note is a nice term for an IOU. If you borrow money, you sign a note. I owe you X amount of money, and over Y number of years, I'm going to pay you so much per month, and at the end of that term, it will be paid off, which we don't use a nice legal term, satisfied. And then you have a mortgage that in New York State that secures the note. So that if someone doesn't pay pursuant to the note, the plaintiff or the lender can then go to court to try to get a judgment to get the property because the person is defaulted in paying. Most states call it a mortgage. Some states have a different term for it. It could be a certificate of trust or some other terms. Usually in southern states they call it that. I couldn't tell you offhand, in other states exactly what they call it, but for our purposes, let's call it a mortgage. So you have to prove there's a mortgage, that the lender defaulted, and you have to prove that on the day the case commenced that you own the mortgage and the note. Sounds easy, but it's not because of all these assignments and paperwork foul-ups and other things that have occurred. But that's what happens in a foreclosure case. So what happens is in New York State, the plaintiff, the lender, or whoever they assigned it to, commences the case in Supreme Court. They file a summons and a complaint, and then they serve it on the defendants, and defendants have a certain period of time to answer. Answer is a legal term meaning a formal piece of paper in which they either admit or deny the allegations. And then from that, once they file an answer, then the case can go forward, and then the next step in a foreclosure case is to get what's called an order of reference, which means the court appoints a referee. That's what the reference is. Referee is a lawyer appointed by the court who can take testimony, issue a report to the court, and the referee represents the court. And the referee's job is to determine if everything that the plaintiff says is true. In other words, that they can compute the amount of money that's owed, and the three things that I've mentioned are there. That somebody, there's a debt, there's a mortgage and a note, that there's a default, and that on the day the case commenced that the plaintiff actually owned this thing. So when the referee issues a report to the court, then the plaintiff can then move for the second step, which is called a judgment of foreclosure and sale. And then the court, I or any other judge will review all the papers, and ultimately we can issue a judgment. And that continues the process, and then there's an auction eventually. Anytime up to the auction being held, or as I like to say, the hammer dropping, person can redeem, meaning that they can pay off the mortgage or negotiate with the lender. And there are times even after that, after the foreclosure has taken place, the sale, that they can still do certain things, really until the buyer at the auction closes, because the referee on behalf of the court will then deed the property to the new owner. So there's a whole process which in New York State, since this crisis began, is very delayed. At the rate we're doing foreclosures in New York State, according to an article I read in the New York Times, it would take somewhere between 70 and 80 years to clear up the backlog. But New York State works, the wheels of justice go very slowly in New York because of the foul-ups. Now, then you can go to other states like Florida, where boom, 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 people are gone from their houses. So, but I think that's because New York's a judicial foreclosure state. So I look at the papers. So I started to read this stuff, and I found there were a lot of problems, especially in determining another principle I'll mention called standing. Standing is the right to proceed with a case, because it means you can get into the court, you can open the door of the courthouse because you own the mortgage and note. You can prove there's a default, and you can prove that you actually own it on the day the case commenced. You meet those three elements I mentioned to you. Well, I started, this goes back approximately 5 years ago, I started to notice some problems with foreclosures. And this is before we went through the crisis in, I guess, late summer or early fall of 2008. After the, Bear Stearns, I think, went under in July or June or July of 2008, and eventually when Lehman Brothers went under, and then TARP came about, and looked like we were in a financial free fall, and everybody was worried about. HBO had a great name for that movie, Too Big to Fail. The world's going to come to an end if we don't rescue people. Guess what? The sun comes out every 24 hours. Even get above the clouds, the sun's there. But anyway, the point is that. I noticed certain things that I would see, strange things, which I didn't even know what to call it at first. I said people wore multiple hats. Well, that ended up being the robo-signer issue. And I discovered some of these robo-signers.
What do you mean by that?
Robo-signers. These are people who, well, let me back up. I'm trying to simplify it in lay terms. Most people, it's gotten better, but probably, at least in my county, 90% of the people who were sued in foreclosure didn't have the money to pay to redeem the property. They were in they were suffering financial hardships, so they didn't come to court. They figured they're going to lose their house anyway. So that's a default. So to get a default judgment in New York State, which is ultimately what will happen after the order of reference and the judgment. The plaintiff or a representative of the plaintiff, someone who has a power of attorney, has to file what's called an affidavit of merit with the court. So if it's the plaintiff, it's a corporation usually, I am the vice president of Bank X, and I have examined all the papers, I'm personally familiar, and the person is in default, and they're supposed to pay us in this date, and they haven't paid us, and it goes on and on and on. That's what you would think in an affidavit of merit. But a lot of banks have given powers of attorney to mortgage services. So they would. So I am a vice president of whoever, and I am the authorized attorney in fact for Bank X. So that would be another affidavit of merit. So that's one issue. Also related to it, we have this other thing called MERS, M-E-R-S, which stands for Mortgage Electronic Registration Systems Incorporated. MERS, which is really a subsidiary of another big outfit called MERS Corp. And since I have people here from Alexandria, Virginia, who I know are here, that's where MERS is located. Their corporate headquarters is in Alexandria, Virginia. MERS was created at the beginning of the Clinton presidency by numerous big banks. So you can figure out who the usual suspects are. Sounds like Casablanca. Round them up. But the ones you are familiar with, they created MERS. I compare MERS to OPEC. It's a cartel. And the idea behind MERS was to have some kind of computerized registry to move mortgages around, and also to in a way to save banks money. Because what happens is that when someone gets a mortgage and a note, it's recorded. And depending upon where you are in the United States, it could be a county clerk, it could be called a recorder's office. In New York City, it's called the city register. New York has got to be different in New York City. And there are different agencies that record it. And depending upon the number of pages in the mortgage, there are filing fees. Usually so much per page because it gets put, at one time it was on microfilm, now it's scanned. So in New York City, I don't forget if it's $4 a page or $5 a page. There's some kind of figure, whatever it is. So somebody could record a mortgage. It could be $50, $75. Doesn't sound like much money. and the person who borrows the money is going to pay the recording fee to the title company who's going to have it recorded. And typically what would happen is each time the mortgage would get assigned, it would be sold to somebody else, there'd be another recording fee. But what happened is that the bank set up this thing called MERS, and MERS would be, as the nominee, which is some kind of agent, as the nominee for the lenders, would record the mortgage. And then on the MERS system, MERS created this system of which the banks and the financial institutions were members. They would move these mortgages around. But nobody would know because they're not paying the recording fees. So it sounds, you know, $50 here, $75 there, $100 there in recording. It got to the point now where the estimates are that MERS probably has saved the banks since '93 about $3 billion in recording fees. So it's $3 billion that didn't go to counties in the United States or New York City or localities, and $3 billion that could have been used to fix roads, hospitals, schools.
Why not? Why did they not get paid?
Because mortgage is recorded on the MERS system, and it stays there, and maybe it's assigned 5 times in the MERS system, but nobody knows, except unless you're in the MERS system, and you got to pay a fee to get on the MERS system.
Is that illegal, what they've done?
No. The problem arises when it comes to a foreclosure. So now what happens is MERS has certain rules that MERS members have, and these are the big banks usually, but not always. And what happens is that, at least I know in New York State, that MERS cannot foreclose on mortgages under their rules. So MERS will then assign the mortgage and the note to whoever actually is alleges to be the holder of it. So what will happen is that you'll see an assignment by somebody who is named as the assistant secretary, or everybody's an assistant. Assistant secretary, assistant vice president, assistant treasurer of MERS. MERS only has about, at one point had about 45 actual employees. I think there are less right now in Alexandria. And there are thousands of assistant VPs, assistant this, assistant that, who then assign these mortgages and notes. And then I started to notice someone, Joe Smith, I'll make up a name. So Joe Smith assigns the mortgage to a bank as assistant vice president of MERS. And then a month or two later, Joe Smith is going to be the officer of the bank. Now that's the second hat with the affidavit of merit. And it goes on. And then I would see different cases where Joe Smith might be vice president of Bank A, vice president of MERS, or assistant vice president of MERS, vice president of Bank B, C, D, E, F, and it goes on and on and on. So you wonder, what's going on here? And so that was an eye-opener. And then you would notice sometimes variations in the signatures. I've written about that. So then you find that the person has, like, there's a particular case that I'm trying to remember when this case was published. Well, yeah, decision that came down last summer. I don't want to really get into it because it probably will be appealed. I can almost guarantee it will be appealed by a major international bank, in which I found 5 variations of one particular robo-signer who assigned the mortgage, and then someone else who with affidavits of merit. Found 3 robo-signers in this particular case. So I don't want to get into it, but because I can't talk about pending cases. But 60 Minutes did a piece. Scott Pelley did a piece about someone named Linda Green, who I don't know how many people signed as Linda Green. Or there's a lawyer up in Maine named Tom, very good lawyer named Tom Cox, who for years did work for banks. Now he's on his own defending people in foreclosures, and he discovered a guy named Jeffrey Stefan, who I think also have numerous variations on his signatures. And it came out that these people, these robo-signers, at least with the assignments or the affidavits of merit, they could be signing like 750, 1,000 of these a week. And the notary could not be in the room. And they aren't looking at all the stuff that they're signing. It's just churning it out for the courts to satisfy the legal requirements of the courts. So these are the screw-ups in paperwork that you would read about. And I uncovered some of these robo-signers, so did a number of other judges and other individuals. So if you Google my name, you can read about some of these cases. That's the easy way. If you're a lawyer, there's something called Westlaw or Lexis. You can put in my name and you'll read about some of these cases. So if you want to do the research, you can read about it. I don't want to talk about it. But I uncovered some of this, and so I got some notoriety on this, and I disallowed some of these foreclosures from proceeding. So it's gotten to the point now when I get a case for an order of reference, I check I scrutinize the papers. If it gets past the order of reference stage, it might very well, if the person doesn't modify the mortgage of the bank, get to the judgment of foreclosure. And despite what Harold might have said and some of the other things I've done, I actually approve foreclosures too. Unfortunately, it happens. New York State's done some other things to try to help people. So the answering rate of defendants has improved. We've reached out to community groups, other people. We've also now in New York State, the state legislature changed the law almost 2 years ago, where people have, if you are an owner or an occupier in a 1, 2, 3, or 4 family home, so you have to live there. It could be a 1 family or at least in one of the apartments. You have a right to have a settlement, a mandatory conference with whoever owns your mortgage to try to modify the mortgage if we can. Because under the Obama administration, we had HAMP, which stands for Homeowner Assistance Modification Program, also tries to help people. It hasn't been the great success people thought it might be, but it's whatever we can to help people works. I heard a statistic today only because in my court, a number of us who are Supreme Court judges who deal with this actually met with Southern District numerous bankruptcy judges, because we have overlapping jurisdiction in this area, and we have a community of interest, so we actually talk to each other. So we held a meeting at Federal Bankruptcy Court in Brooklyn today. So one of our administrative judges came up with some statistics which I was not aware of. That in the last year we've had over 6,000 of these mandatory, 6,000 mortgage cases. We had settlement conferences going on, and we actually have achieved almost 900 modifications in Kings County, which it's 900 homes that might not have been saved before. So at least that's good if we can help people. But there are lots of people we don't help, because there are thousands more that either they don't come to these conferences, or ultimately we can't get a settlement. But in New York State, the lenders now and the borrowers have to negotiate in good faith. So those are other problems that happen over what's good faith as opposed to bad faith. So there are certain things we're trying to do to help people. Now, other states don't have this in place. So it becomes a very involved issue, and this is why things drag on. And we are really backed up with foreclosures. We're literally, I can get case. Well, by the time I get the case from our clerks, this thing could have been sitting around for a year or two, because we just don't have enough clerks, enough workers, because we've had budgetary cuts throughout the state in terms of court operations. We sustained a big cut last year, bigger than what we wanted to. We also had very experienced court employees, clerks who took a pension buyout last year because they got several extra years to retire early. And then we had some layoffs, and I could go on. And this is one of the problems. You know, we want to provide justice for people, but we need the resources, the human resources in the courts. We have less resources. So we got more cases, less resources. And so I got to prioritize what I do. So I get to it. I try to get to it. And sometimes if a settlement conference doesn't work, it could be a number of meetings. Ultimately, it comes to me. And I have found that I've had the unique experience that I get modifications for some reason that other judges don't. So you draw your own conclusions about bank lawyers coming to see me. Or I get the other strange thing that happens, where we have, because of the securitization, which I didn't even get into, of mortgages, where banks in the last 15, 20 years have packaged these mortgages, sold bonds based on mortgages, created all these strange financial instruments. We have the situation where I will see a caption that will say, Bank X is the indentured trustee for the registered note holders of the 2004-S2 trust, crazy names. So you have a trustee, and you got another bank that's the master servicer, and somebody else is the servicer, and it goes on and on and on. So go figure out who owns this thing. And what it is you have mutual funds, you have pension funds, insurance companies. They're the investors, major institutional investors. So I can work out a modification, or an attempt to work out a modification, where somebody might have a lower interest rate, they might take a longer period of time to pay this, but at least keep somebody in the house. And then the lawyer for the plaintiff will then say to me, I have to check to see whether the investor, meaning whoever owns the bonds on this particular mortgage, will approve of this modification. Then that's usually followed by the question of, well, who is the investor? And then I get the answer, I don't know. So that's one of the other problems in dealing with foreclosure. So then I adjourn it, let's find out who the investor is. So sometimes they'd rather not fight with me, so sometimes I found out I've been able to get modifications sometimes and other judges aren't. But again, it's on a case-by-case basis. But when you get an old-fashioned, what I call an old-fashioned mortgage, where you didn't go through mortgage brokers, and somebody, usually it's a community-based or a smaller bank or a credit union, somebody went there and they serviced it and they didn't assign the thing, it's very easy to prove. We own it, the person defaulted, and we owned it the day the case commenced. Those cases is a little more, it's difficult to save people's houses, so those cases I sign judgments, so it depends upon the case. So it goes on and on and on. Other cases, it moves rather quickly. Non-judicial foreclosure case, the burden's on the defendant to go to court and try to stop it, and things move rather rapidly in selling people's houses. So that's why Florida has a lot of notoriety, especially in the west coast of Florida, from roughly, I guess, St. Petersburg south to roughly Fort Myers. That's like foreclosure central, or Las Vegas, certain parts of Arizona, California, terrible shape. A lot worse than New York. So, but even where I am in Brooklyn, probably we had, well, it changed. I'll tell you why in the fall of 2010. But we were running in 2010. We probably had about 10,000 foreclosure filings. I know we have pending about 15,000 foreclosures in Brooklyn, the most in the state, of about 75 to 80,000 pending foreclosures. But actually, Suffolk County is probably the worst. They have the most per judge, is probably a better way to look at it, per capita. Less total foreclosures. And again, Suffolk has the same problem we find throughout the city. It's minority communities where you have more foreclosures, because people run into financial difficulties. Maybe they had 2 or 3 jobs. Somebody loses jobs, then the family runs into financial problems. So typically, I can tell you in my county in Brooklyn, East New York will lead in foreclosures, Canarsie, Bushwick, Brownsville. Then you flip it around to predominantly white neighborhoods, Bay Ridge, Park Slope, a lot of yuppies and people who make a lot of money, Brooklyn Heights. Very much rarer to see foreclosures there, but it happens. People run into problems. So probably 90% of the foreclosures in Brooklyn are in predominantly minority neighborhoods, but it's all over foreclosures. I mean, it happens. So that's one of the other problems we face. So there are a number, and that leads also to societal issues. You move somebody out of a house, you evict them in a foreclosure, then you have the problems of empty houses, blight in a neighborhood, who goes into these houses. You have the other problems of you have tenants in houses. What if you have a multiple dwelling and it goes to full people, they foreclose on the house? Who's going to provide services for the tenants? So there are numerous issues, human issues that go along with the legal issues in dealing with this. So I'm aware of it. Other judges are aware of it. So we have to deal with this stuff. So it's a major problem we face in this country. So that gives you a piece of what we do. But suddenly it slowed up about on October 20th of 2010. On October 20th, 2010, the New York State courts mandated a rule in which bank lawyers have to affirm under penalty of perjury that they don't have robo-signing in their foreclosure filings. So the notarizations are accurate, the statements by the banks are accurate, and they're subject to sanction or discipline. So I've had cases where the bank lawyers are afraid to file these things because they know there might be problems. So I've dismissed foreclosures because they violated this administrative order of the chief administrative judge. They violate my orders, give me an affirmation, usually in 60 days. They can't do it.
When you dismiss a foreclosure, what happens to the money that's owed?
Well, that's one of the problems when you dismiss them, because the interest can mount unless we can work out a modification. Or maybe the case won't start again. Who knows? So depending on how bad, egregious what the banks do, it could be dismissed with or without prejudice. With prejudice means they have to start the case all over again. Without prejudice means you don't have to start all over again. So because when I dismiss it, if it's with prejudice, it's on procedural grounds, meaning you can start all over again. Also, we do something which I don't think they do in every county in New York State. We index foreclosures by lot and block. So suppose a bank isn't happy with the judge who gets the case. It's all done by computer. It's done at random. So I'm assigned a foreclosure on a certain block and lot is commenced. So once somebody files an answer, or they default, gets assigned to a judge. So I get it at random. The computer picks me. I'm one of about 25 judges who will do, or 30 judges who do this in my county. So if they want to get away from me and discontinue the case, and that happens, if they can't give me affirmations, I get discontinuances, meaning we stop the case, we start all over again. The computer knows, because it's all buried in there, that block 1, 2, 3, 4, lot 3, whatever it is a Judge Schack case. So as long as I'm a judge, and this case is started all over again, or a foreclosure in this particular lot and block, it's going to come back to me. So the banks can't escape me. Now, other counties might work differently. I can only speak for my county. We like to joke, New York State has what we call the unified court system. And we have 62 counties. So in the end, it's 62 different ways of doing everything, even though it's unified. So on certain things. So because we have local rules also. I go on about that, about 62 different ways of doing everything, even though the courts were supposedly unified back in the late 70s. So foreclosure is a particular problem. So this is the iceberg we have. They start cases, but they don't want to give you the affirmation. So case law is developed, and I, among other judges who have got involved with sanctioning lawyers who have not been truthful in their affirmations. So if you want to read about it, go Google my name. If you're a lawyer, go on Westlaw, because I really don't want to talk about these cases because some of them are winding their way through the appellate process. So I really can't comment. But you'll be rather amused if you read some of the stuff or some of the newspaper articles or magazine articles about it. So that gives you a little flavor for foreclosure. So I know I've been probably rattling on and on, so I don't know if people have any questions for me. I like to throw the floor open.
Yeah, and could I say, if you give a question, the mic is there on him, so if you could speak up when you bring the question. So
Harold, I don't know whether you guys, or Joe, whether you have something monitoring the sound, so if you want, I'll repeat the question.
Yeah, you can repeat the
Fine.
question.
Thank you, Joe.
If you ask a question, speak up, don't whisper.
I'll give Joe a credit as you're able.
He's very good.
You're able. What's your title? Production director or something?
Director of the whole shebang.
Okay.
I have a question.
Yes, Maggie.
Did you do a mic check?
Speak up, Maggie.
How do?
Speak up. Speak up. Speak up.
First and foremost, I welcome you here.
Thank you,
Yay.
and I appreciate your hospitality.
One small little question.
Now you sound like Lieutenant Columbo. Always had one last question.
right.
You got to get the dirty raincoat, Maggie. But okay, I'm just kidding.
If the bank realizes it is I don't know what to say, culpable in the doghouse, etc., cannot prove it, it simply has no loan on the property, how do they restitute the fact that they would graciously say, fine, we don't have a loan and the property is yours, free and clear? Is there a term for that?
Well, I have a number of cases in which I think the banks know they have problems proving that they own the mortgage, or there could be robo-signers, who knows what. So I get these notices, or sometimes they get the defendants to sign what we call stipulations or notices of discontinuance. So they terminate the case. And then what will happen is ultimately down the road, if the mortgage is not modified, if there's sometimes somebody could sell the house too. Things could happen when mortgages are paid off. They want to start the case all over again. It comes back to me. But I have gotten some cases which I thought were bizarre, where mortgages are actually paid off. Satisfied is the legal term, because you get a piece of paper. It looks like it says satisfaction on it. It means that it's paid off. Where the bank lawyers were too lazy to inform the court that the mortgage is paid off. They commenced an action. The person then satisfied the mortgage, and months, or in one case, a year or so later, no one tells me, and I'm sitting there with the papers to issue a judgment of foreclosure or an order of reference. But I check the paperwork. So I go online and I check in New York City. It's called ACRIS, Automated City Register Information System. So I have the software, and I can actually see this chain of title, recorded mortgages and deeds, and I have found recorded satisfactions. So if I hadn't bothered to check, I would then issue a judgment screw up somebody's credit. That could be, I don't know how it could be good or bad, but it's going to be worse, and it creates a problem for the homeowner or former homeowner to clean up the credit. So I have then brought in lawyers to be sanctioned for, why didn't you discontinue this case? Why, this is an injustice to somebody. They paid off the mortgage. Why, there's a satisfaction. Why are you going forward with this case? To which, and then they apologize. And they tell me they're changing internally all their procedures.
Okay.
But I've had that happen a few times because I bothered to check the paperwork.
Now, on the tougher side, when the bank realizes it has no position, no ability to go forward.
Then they should discontinue the case.
No, and what is the proper term for the bank saying, this debt is clear, this debt is...
Well, they could be, somewhere along the way, there should have been a satisfaction. So in other words, when someone pays off the note, really, and the mortgage, even though we like to say mortgage, it's really the note, the bank then has the duty, they'll charge you $50 or $75 because they love to, well, I won't get into their business practices because they got to issue a piece of paper, they got to process it. So I don't want to say they nickel and dime you, but you know, that $50 or $75 is a lot of money. Yeah, you know, I'll quote Everett Dirksen, who said, you know, you add it up, soon you got lots of big money there. So what's going to happen is you pay a fee, and you get this piece of paper called the satisfaction. But it also puts everybody on notice to the world that it's recorded. Also, I've tested something that should be done. This MERS is one of the problems. I have testified before the New York State Senate, actually when Eric Schneiderman was a state senator. And he chaired the, I think it was the Judiciary Committee. It was a joint session with Judiciary and I forget the other committee. Myself, I know, was a district attorney in Kings County. Independently, we both said the same thing. This is the cut down on fraud, that any assignment should be recorded. In New York State, they don't have to be recorded. So it's the same even with mortgages. Technically, you don't have to record them. But anything to be enforceable in court should be recorded, which would cut down on fraud. Because I didn't even get into all the fraudulent things that happen in conveying property. You get straw men to supposedly buy the property. And we have people defraud out of their houses because they think they're refinancing their house when they signed over a deed to some crook. I mean, that's a whole other area where I haven't gotten into that.
How long does that go back? 1802?
What's that? In
the property.
Well, we have chain of, if you want to go back through the microfilm and the dusty records before the microfilm that are, you know, you can go back 200 years or whatever land records show in New York City. I mean, we have that if you really want to do that. You really don't have to do that. But they have, it's called a chain of title. So who actually owns property, who owns mortgages. New York State is also what we call a race notice state, which means that you could sign a mortgage with one lender, and then you could have a second mortgage or a third mortgage. But whoever records the mortgage first is the senior lienor. So that can become an issue. It's called the race to the courthouse. And I've had cases where, well, you can read about, I think this one's actually finished. It was Wells Fargo, but you can look at it with somebody else who was, who was the senior lienor. And even though the Wells Fargo gave out the mortgage first, somebody else 15 months later recorded it, and Wells Fargo didn't record the mortgage. So when somebody defaulted, guess what? Wells Fargo loses. That case, because the other person who was some kind of private investor recorded it first. And Wells Fargo blamed everybody but Wells Fargo. So I quoted that famous quote from Julius Caesar that the Cassius, the fault, the Cassius lies not in the stars but in ourselves, because they blamed everybody else. So I quoted Shakespeare in that case.
So the money's just forgotten then?
No. There was a judgment of foreclosure, but it wasn't for Wells Fargo because the other holder of the mortgage got to the courthouse first.
Okay.
But that's a whole separate issue.
Somebody else?
Okay, thank you. Thank you, Brian.
Yes.
Judge Schack, how do you account for the research, for example, from Mr. Raja? He's done investigation into a sample loan note that showed a $400,000 note created over $90 million for the banking system. Who is getting all that money?
I don't know. I don't have answers for you. I don't have, you know, I'm not a forensic investigator. I have to deal on a case-by-case basis, what I have in front of me. So I am not an attorney general. I'm not the SEC. I'm not the FBI or whoever's dealing with this stuff, or local police, or well, it depends upon where you are. So it could be, I'll pick on my county again. At one time, dealing with real estate fraud, we had one assistant district attorney. I know the gentleman, he's a good guy. And over the years, he's expanded his unit where I don't know if he has 10 or 12 people who work for him, other lawyers who are all assistant district attorneys, because this is just dealing with mortgage fraud. And I've referred cases to him where I've discovered things that I think are rather bizarre and strange. You know, it wasn't, I could think of one case where we had a guy arrested in my courtroom. It wasn't actually on a foreclosure, but he was selling property he didn't own. And I don't want to even get into this stuff. But to explain, it'll take too long, how he was able to get away with this for a while. But it ended up a title company was on the hook for about $750,000 when I avoided various deeds. And then the guy went to jail for several years. And then he came back, and I said, "Where were you for the last few years?" He says, "You know where I was, Judge. I was indisposed," because he was trying to do it again. But that's a whole other area that I'll call real estate fraud. And it's related to foreclosures as well. This wasn't a foreclosure case, though. But he literally stole property from somebody who actually owned these corporations, because somebody didn't pay a certain tax. So this guy was able to get a hold of the corporate name. Eventually got corrected.
I'm talking about the securitization.
But the securitization and the stuff there, that is, I'm just, beyond me in terms of doing investigations.
Who could we take it to, having already been to FBI?
All I'll tell you is, you got to go to your local law enforcement, your congressman, your senator. That's beyond, that's the best I could tell you, because I can't deal with it. I'm not a one-man enforcement unit. As I said, I got to deal each case. Well, I appreciate that, but I'm not I'm not Superman. I'm just trying to do my job. Because people have said all kinds of things, and I said, I hate to, I like to make their movie references sometimes, but I thought of this once, and I used this expression. There's a famous war movie called Guadalcanal Diary, which who remember? I don't know if people remember it. William Bendix is an actor. Who remembers William Bendix? He always played guys from Brooklyn. And there's a scene in the movie in which somebody said something to him. They're about to land in Guadalcanal in the first wave, and he says, "I'm just a guy. I'm just trying to do my job. I want to go home." So I'm just a guy. I'm trying to do my job and be fair to everybody. So since William Bendix played a guy from Brooklyn in the movie, and I'm from Brooklyn, so I'll compare myself to William Bendix. I'm just a guy trying to do my job. And maybe get to my wife at night if they let me.
Okay.
Is there something called squatter's rights? So, I mean, if someone's living in a building for more than 6 months, even if it's foreclosed and you owned it, if you've been living there, how do they evict someone if you have squatters?
All right, that has nothing to do with, technically, it could end up in my court. Usually in New York City, it ends up in housing court. Right. But people can move to eject or evict, depending on the case, people who are squatters. Mm-hmm. You don't necessarily have a right to be there if you're there X amount of time.
I see.
Or you could be hit for what's called use and occupancy. Anybody else?
Yeah. Oh, Polly?
Does a forensic examination help you do your job?
I usually don't get them in foreclosure cases, but certainly it can help, depending upon, again, it's hard to answer something in the abstract. It depends upon the unique facts and circumstances of a case. So I'll use a nice Latin term, sui generis. Every case is unique. So I'll use that Latin term, sui generis. So no two cases are alike.
But you did your own examination when you went on.
Because those are public records, I'm allowed to do that. So I'd like to know, basically I'll quote Ronald Reagan when he met with Gorbachev, because talking about nuclear disarmament, he says, "I trust you, but we have to verify." So I tell that to the lawyers all the time. "Judge, we own this thing." I said, "Okay, but let me verify just to be sure." So I quote President Reagan with that. I trust, but I'll verify. Which is really saying, I don't know if I really trust you, but that's neither here. But that was a cute line that Reagan used. So I check it out, and it's a public record to see who owns this thing. I go to SEC filings too when I check things out.
So you have an inside look at the system, and all these foreclosures are happening. Is there something wrong going on here? Do you have any suggestions? All these people, what do you think is wrong? I mean, just as a public servant, you must.
Well, I see numerous cases with questionable documents that are filed. And I have to deal with them
Like
case by
banks.
case. Well, whoever alleges to own the mortgage, a note, yes, it could be, bank is, I'll use a generic term. It could be a credit union. It could be a major financial firm on Wall Street. Well, then again, they all became banks. Goldman Sachs is now technically a bank.
But what do we do about the whole problem that's going on, not just in
All right.
New York, around the country?
Talk to your congressman. Talk to your
What
legislators.
do you suggest as someone who
My
knows
job,
the system?
I hate to be a cop-out. I don't make the laws. I carry them. I help enforce them and carry them out and see if people don't break the laws.
As a citizen, do you have any suggestions?
You can make, my problem as a judge, I'm a second-class citizen. My First Amendment right, you have more First Amendment rights than I do. I can't get
As
into
a
this.
human being, forget citizen, you as a human, someone who
Alan,
wants.
Alan, as a human, he cared enough to go on Actress and.
Oh, I like this lady. I'm trying to be fair. So we have an expression. As a judge, you try to do justice. So I do justice. In my own feeble way, I attempt to do justice. And sometimes people's homes are saved, and sometimes they're not. It depends upon, again, the facts and circumstances. When I do it, if we have a trial, somebody's going to be happy, and if there's a verdict, then somebody's going to be unhappy. That's the unfortunate part of being a judge sometimes. That's why sometimes I like performing wedding ceremonies. Everybody's happy. No one's upset.
Is something wrong with the banking system in this country?
There might very well be, and it needs to be reformed.
Hi, I was wondering, do you think it's getting harder and harder for judges to ignore what's going on? I mean, can judges take judicial notice of, Senator Levin's investigation about what's caused the banking crisis?
Well, I have quoted, and if you read some of my decisions, you'll see when Senator Dodd chaired the banking committee, I've quoted Senator Dodd. I've quoted some other members of Congress and some of the things that occurred because they're public record, and making points I've made. So, but that's really a legislative thing in checking, what's going on. It's a legislative function or a prosecutorial function to clean up things, or a regulatory function. It's not my function as a judge. I have to deal with a case on a case-by-case basis. So that's the problem I have. I'm not, I can't usurp the authority of regulatory agencies. I can't usurp the power of Congress to make laws or the state legislature. But I have to interpret them.
But do you think there's more occasion where the attorneys who represent homeowners can come to you and say, will you please take judicial notice of this?
All right, judicial notice is a term which means that if something is commonly accepted as being a fact, then you don't have to prove it. But judicial notice would be something here. I have a case now dealing with an accident on 9th Avenue and an automobile accident, 9th Avenue and 48th Street. So to save 10 minutes of testimony about the flow of traffic, I took judicial notice that 9th Avenue goes one-way street north to south. West 48th Street goes from west to east. Save 10 minutes in the trial because everybody understands that. Nobody disagrees. That's the kind of thing where you take judicial notice. But in terms of other things like that, again, you really can't take judicial notice that we have a crisis. You got to look at specific facts, and then you have to make them fit, I guess, the circumstances of what's going on in this country. But so judicial notice doesn't really apply to a lot of the foreclosures cases that I do. So judicial notice, 2 + 2 is 4. That's judicial. I'll take judicial notice of that. Those are the kind of things you take judicial notice of. You don't have to prove it.
What did you have in mind by that question?
Well, I mean, for example, if a bank has signed a cease and desist consent order with the Office of the Controller of the Currency, they haven't admitted doing anything wrong, but they've been found to have had certain practices and patterns. That's what I was thinking.
Okay, that is a
in
fact.
particular. Thanks.
But somebody
Teasing that
still
out.
would have to, let me think of it, try to like that full foreclosure.
They have a bank or has settled for defrauding such and such, or has been accused of origination.
All right, somebody would have
fraud, lending,
to,
something like
I would
that.
have covered that, somebody would present.
Court as an exhibit, so you have to take, well, in that sense, maybe judicial notice isn't the right term, but it's something that somebody proved. So you can take that into account if it's related to how you're going to rule on a particular motion or in a case. So you could that. I see your point, but certainly if that's a fact, that's a fact that you have to be aware of. Yes, so it's some kind of admission. Well, of course, sometimes depends on what's admitted. Sometimes you have what are called, federal court especially, you have what's called consent decrees. In other words, people agree or they stipulate to something without bearing liability. They get very cutely worded, these documents. So you have to be careful in looking at these things. Yes?
Joe?
Yeah.
Joe Brennan?
Can you stop it for a while, because I want to ask something that I don't want to have on the tape.
Well, ask
Can you do
afterwards.
that?
Ask
It
afterwards.
can go about a minute and a half because we're coming to
Okay.
an hour. No, just a quick question, real quick. Anybody got a quickie
Maggie.
they could get?
Real quick. I
Really?
have
Yeah?
a law firm representing my bank who says to me, oh, we've just had the vested interest in a loan from Washington Mutual, but we have missing documents.
Oh, wow.
Now, the legal firm
It's now Chase.
representing,
Oh, Chase. Wow.
they did not put the date on the letter in which they wrote to me, but they gave me legal documents.
Maggie, I can't give you specific advice in your case.
Is it
See a lawyer.
credible that a law firm would not put a date on the letter?
You'd be amazed at things I see.
Okay, that's a
People leave out dates. They give you documents. They forget to sign it. It doesn't have to necessarily be a foreclosure. It's just amazing what they do. Or they give the wrong address, and then I ask them about, oh, we made a mistake. I said, that's nice. What else isn't true in this document? But that could be on anything.
Okay,
So-
we're just about stopping for an hour. We're going to change tape now.
Okay, is this the end, or
No, not at all. We're just changing.
if you want to ask about something other than foreclosure, feel free.
Actually, you appear to be an honorable man, and
Well, so some people might disagree with you, but I'll accept that.
talk about the issue of fairness. And so I'm going to change, now for something completely different. You can go back to the mortgage fraud if you want to. But
It's a timely topic. That's why Harold asked me to talk about that.
Josh Valinsky is a producer at M&N, and I'm a producer at Manhattan Neighborhood Network. And he's been very helpful with one of my issues. And one of my issues, and I didn't know, I like you, discovered something, and I'm amazed by it. I was illegally expelled from Yeshiva University's medical school without a fair hearing. I was not permitted to be in the hearing room while my professors gave false unsworn testimony against me. Thank you so much for that reaction. I thought this was unique to me until other students, Orthodox Jewish students, called me and asked me to be a witness in their cases. And we have common ground because this is a huge civil rights violation.
Well, I would say,
Wait,
yeah.
I'm getting
Oh,
to my
okay.
question. I'm getting to my question. And I thought this was unique to Yeshiva University. It's not, because I got to
Josh?
a highly placed attorney at Andrew Cuomo's State Attorney General's office. He asked me a lot of good questions. I couldn't answer them, so I went out in the field. And for 3 days, I did the legwork myself. And what I discovered, to my horror, was there has never been a fair hearing for a medical school student in New York State since the dawn of time. I was asked to check the policies at all the other schools. I had a checklist. I'm like, oh my goodness. Before you subject a student to a life-altering event like expulsion from medical school, the student should at least be able to be in the room to hear the arguments against them. This is a basic civil rights, human rights issue. So I asked my school to provide a written, published, faculty-approved hearing procedure that fully comports with the spirit of law, and that it says you should be in the room to hear the arguments against you. Wait, I'm almost done. So I put together a group of students, and we didn't ask to be reinstated. We didn't ask to be vindicated. We asked to be in the room to hear the arguments against us. We had insight to the to the attorneys who were managing. They managed out of this all the rights of the accused. We were falsely accused. So I'm wondering, as a human being, not as a judge, because I went to elected officials, I'm going to a lot of elected officials, and I'm thinking, if you made a single phone call to the Yeshiva University's president, Richard Joel, and said, could you, just out of curiosity, as a human being, as a human rights issue, could you fax to my office the written, published, faculty-approved hearing procedure that fully comports with the spirit of the law, that would allow a student to be in the room, what a concept, to hear the arguments against them. You could do a service for thousands of students in the state of New York because they would be too embarrassed to admit that, and you would compel them to make a written, published, faculty-approved hearing procedure.
You're asking me to be an ombudsman.
I'm asking you to be an activist as a human being, not as a judge.
It's a Swedish term, but that's basically what the city, like Bill de Blasio, is technically the ombudsman for New York City as the city council,
This is medical school.
as the public advocate. But you know, that's a private university as far as I know, Yeshiva, correct?
This is all schools,
Correct.
every school.
So
even
all I
in
would
state
suggest to you is get an attorney,
schools.
go to government officials. They probably get some kind of public funding.
They all get federal funding.
I know they do. So pursue it. But I don't have a case in front of me. So I don't have the same First Amendment rights you do. So I'm not going to comment. All I'll tell you is only because it might be related to your thing. Jonas Serrer is a columnist for the New York Times. For the last 2 or 3 weeks, he has an ongoing series about some cases involved with the NCAA, student athletes, and about how they do things you might want to say they're acting like a kangaroo court. Because in my prior life, before I was a judge, no, I wasn't a kangaroo, but I was counsel for the Major League Baseball Players Association. So I was a union lawyer for athletes. And we had to deal with people who were the college baseball players that were drafted, eventually became professional. So I had to deal with interpretations about NCAA rules, which were rather. I'll just say, look at the Serra thing about the NCAA. It sounds almost like this about things that they've done to student athletes, because you got to build. So it's somewhat similar, but about how they operate. So you might find that fascinating. There might be some analogies to your situation. NOCERA. Jonas Serra is a columnist for the New York Times. So he's written about the last, 4 or 5 columns about this, even including one I think was today.
I think that Yeshiva University is so embarrassed, because we actually went to Elie Wiesel, Nobel Peace Prize winner, Holocaust survivor.
I know who he is.
And again, we asked, I wrote a 5-page letter that was presented to him, and again, we didn't ask to be reinstated, we didn't ask to be vindicated, we asked to be in the room. So we appealed to...
So it's what we would call due process.
Well, we didn't have due process.
But if you believe that there's some violation, I'm not the person to go to, because you live in Manhattan?
I live in Brooklyn.
Brooklyn. Well, you might end up in my courts. I don't even want to know about it. If you sue Yeshiva, you have your choice of New York County or Manhattan, if that's what it is.
I'm appealing to you as a human being.
As a human being, I can have feelings, but as a judge, I can't express them. That's really my problem.
That's terrible.
I know. I'm limited to what I can say.
So I'm wondering, since you worked with our state attorney general is Eric
Schneiderman. I've met him on occasion. I know he's taken a big interest as Attorney General in foreclosures.
And fraud, obviously, because you wouldn't. So, is there a way I could bring this to the attention of our new Attorney General?
Well, I don't know his phone number offhand, but he's in the. Go to his website. I'll even tell you the website to go to where you'll find them. Go to ny.gov, and you'll see something for the Attorney General's office. I'm sure there's phone numbers, email addresses, etc. But I'll give you that one, www.ny.gov. You'll find it. And then you got to take it from there.
Anybody else got a question?
Is it true that through a series of historical events, judges have more administrative duties than judicial duties, and that a judge is there to seek agreement between...
No. I try. I'll try to settle the case. That's what I'll call the mediation role. To me, that's a lot of fun. And so, if I'll make it real simple. Well, let's suppose there's an auto accident and somebody has a broken arm, and so I'll try to get the two sides together to try to see if we can settle the case to avoid having a trial. And sometimes I might succeed, and sometimes I don't. But if I don't succeed in settling the case, then the jury's going to make a decision. They're going to be the triers of fact. So that's an arbitration role as opposed to a mediation role. So sometimes it depends on the situation. But that's not administrative. That deals with adjudicating an issue. So if I can bring the parties to an agreement, I'm happy, and we save time for everybody. But if they can't, that's why we have trials. And then depending on what happens in the trial, and we can go through several years of motions and appeals, and who knows what happens. So sometimes that's why people settle cases, because sometimes they take less because it's cheaper. Sometimes it's worth it. It's a business decision for the defendant. So it depends on the specific case. So I'll compare it to a broken arm case or something like that. So sometimes I can settle these cases, and I enjoy doing that because I try to bridge a gap and try to bring two sides together. But that's me. Other judges will just tell the lawyers, open the trial, call your first witness. But I'll attempt to try to settle a case.
I just have one thing. So what you were saying today is that a homeowner shouldn't take it for granted that a bank has the right documentation to foreclose.
Well,
Is that what
listen, if you're a defendant in a case, you got a right to put on. So that if anybody is a defendant in a foreclosure case, first thing is go to court, file an answer, don't default, and then seek legal help. And there's even pro bono, free help depending on your financial situation from various legal services groups that try to help people, but somebody should go to court. And then with the right help, they can determine whether the case is valid or not. So in the abstract, I would say that's the key thing. Go to court, seek legal advice. I'd say that in any kind of case if someone's sued. And then it'll have to play itself out.
But you're saying that as the process developed is that banks aren't really doing the right documentation.
It depends upon the specific case. I have cases where there's great documentation. And guess what? Ultimately, unfortunately, somebody might be foreclosed upon. If so, again, I have to be fair. So if the big bank does its homework and they have it right against little homeowner is going to lose. If on the other hand, big bank doesn't have it right, they got a problem. So it depends upon the case. Every case is different. So unfortunately, I can't give you a one-size-fits-all answer.
Well, that's what I hear from you. What you're saying is, what you were describing is don't take anything for granted. Go down there, get represented, and the documentation might not be right.
I don't know what that means, but
We're in the dark.
somebody turn a switch.
Big banks pull the switch.
Maggie? Maggie? Is it a
Maggie?
Lost the light.
Somebody,
Is your computer on?
is the camera off?
the camera's it's all off, yeah. So we're in the dark.
So tell Mary Chase on behalf of WAMO pulled the plug on us since we're off the air.
Talk among yourselves in the dark.
Thank you very much for your time.
You're welcome. I hope it's helpful.
It is, thank you.
It's a spiritual reminder that this is the people's issue.
That's people's what? Oh, there we go. How much longer do you want to go, Harold?
Well, we can go a few more minutes if you want. It's up to the
I'm willing to
people.
go if the people want to ask questions.
If they want to make, if people want to make questions, there's somebody who wants to make a question to the judge who's got great knowledge, and I know there's a lot of people here who are very interested in specific. Somebody who hasn't asked a question, maybe you don't have anything, Joe, you don't?
No.
No, okay. Roger, would you want to make any questions? No? Okay. You're very
Could I ask
knowledgeable.
you a quick question? What does the word standing mean?
Oh, okay.
You have the right to proceed with your case because you have proven you have an interest in adjudicating the issue. In other words, in a foreclosure case, it means you actually own the mortgage and the note, and there's a default, and you don't know when the case commenced or it's assigned to you as the case can continue, and that you meet all the elements of it. So that's what standing refers to.
So please correct me if I'm wrong, but if a person has standing, that means they were, let's say they're a plaintiff, they're coming to a judge or a court of law and they're saying, I was harmed by this act.
Oh, well, you can say I was damaged because so-and-so did something to me, or whoever they are, and then you have a right to proceed.
So just on its face, if you come to a judge and say, you come to court and you're the plaintiff and you say, I was harmed by this, I was damaged, you would have standing.
Correct.
Would she have standing if they said this is a private medical school and you can do?
No,
Standing is a different issue. That's different. She might very well. I mean, I can't. I can't give legal advice. That's one of the constraints I
I wasn't
have.
asking you for legal advice, I was appealing to you as a human.
I understand that. But that's like a backdoor way of getting legal advice.
I was trying to compel you to make, because I'm sitting here thinking, here's a person of, who appears to be honorable, and you have some standing in your community, and I was thinking, you know, if you would make a single phone call, even a
I
private-
can't. I'm serious, because you might have I can't even, because you might have a case that goes against, you know, in your case was yeshiva. And further, you know, you live in Brooklyn. You, as a plaintiff, you determine what's called venue. That's where a case would be heard. Venue is based on where either the parties live or where the alleged damage took place. So, for argument's sake, if you were to sue Yeshiva University, which is in Manhattan, you could sue in Brooklyn, Kings County, or New York County. You have a choice. So theoretically, this case could end up in front of me. So that's why I don't want to even. I really can't get involved with it.
In answer to your question, even though it's a private school, they get lots of federal money.
All medical schools get federal money.
Yeah, so we all have an interest in making sure that, I mean, I was appalled when it happened to me. When other students called me and told me, I was shocked. When the New York State Attorney General's office sent me out in the field and I discovered that this is going on in all 9 medical schools in the state of New York since the dawn of time, I'm like, this is beyond a human right.
It's not the dawn of time, it's the dawn of the Rockefellers knocking out homeopathy, so that's only the early 1900s. It's fixing.
I hope
If they want to go by the
Listen,
Constitution.
seek legal advice is all I can tell you. And justice hopefully will prevail. Hopefully. Doesn't always. And that's why we have appellate courts, if you don't think you have justice.